while there was a word from the investigating officers before they filed it, having looked at it, depending on the ruling, we may make a word. So probably wait for the ruling before I could comment on the affidavit.
ABDUL, ZAHIR, QADEER, seriously upstanding. So I'll read until when the other prosecutor comes in, and then I'll summarize and get the finding. Alright, so this is the ruling. So for determination, it's an extradition application by the Director of Public Prosecution, the applicant hearing, against the respondent, ABDUL ZAHIR QADEER, A.K.A. HAJI ABDUL ZAHIR. So extradition is defined in Halsbury Laws of England, 4th edition, volume 18, at page 74, and I quote, extradition is the formal surrender by one country to another based on reciprocal arrangements, partly judicial and partly administrative, of an individual accused or convicted of a serious offense committed outside the territory of the extraditing country and within the jurisdiction of the requesting country, which being competent by its own law to try and punish him or her, demands the fugitive surrendered. So it encompasses the legal process by which one country or jurisdiction formally requests the surrender of an individual to face criminal charges or serve a sentence in another country. So concomitantly, this involves a treaty between two countries which outlines the specific legal framework for extradition, including what crimes are extraditable and procedure to follow, and the protections offered to an individual being sought. So the Apex Court, in the seminal and tedious decision of Director of Public Prosecution versus Okemo, and 4 others, it delineated the distinction between the role of the AG and the Director of Public Prosecution. So whether this court is close to the requisite jurisdiction to entertain this application is indubitable. I'm not going to the law, I've cited it here. So the applicant, through a notice of motion dated the 15th day of April 2025, expressed to be brought under Article 49(1)(f) and G, Article 157(6)(a) of our Constitution, Section 36(a) of the Criminal Procedure Code, and that is Cap 75, Section 7, 9, 12, and 14 of the Extradition, Contiguous, and Foreign Countries Act, Cap 76, Article 11 of the Extradition Treaty between the United States and the United Kingdom, that is December 22nd, 1931, dated December 22nd, 1931, made applicable to Kenya on the 24th day of June 1935, and also the extradition agreement between the United States and Kenya, which was concluded on the 19th of August 1995. They have also cited or expressed rely on the United Nations Convention Against Narcotic Drugs and Psychotropic Substance, 1988, Section 59(2), that is our laws, Narcotic Drugs and Psychotropic Substance Control Act number 4 of 1984, and all the other enabling provisions of the law. They sought 3 orders. The first one was spent. The second one was that the warrants of arrest issued against the respondent by the United States District Court for the Southern District of New York, which is herein referred as the U.S. District Court in the United States of America, on the 25th day of March 2025, be endorsed in accordance with and in the manner authorized by the law for the execution thereof in Kenya. That the respondent be ordered to be returned and or conveyed out of Kenya and surrendered to the USA to face charges for narcotics importation conspiracy under 21 USC 963, possession of machine guns and destructive devices under that United States Code number 924C, and conspiracy to possess machine guns and destructive devices under 18 USC, that is United States Code 924, and this lays the basis of the subject charges for which he was formally charged via case number 1 25 MJ30 in the United States District Court. So the application is premised on the grounds on the face of that application the applicant and the partials supporting affidavit of Sergeant Fred Makora, sworn on the 16th of April 2025. He deposes inter alia that the United States Drug Enforcement Administration, DEA, Special Agent Nicolas, who is herein De Francisco, herein referred as the DEA Special Agent, filed a criminal complaint before the United States District Court, vide case number 1 of 2025/28845 against the respondent. They have annexed a copy of the complaint, which is dated 25th of March 2025. He further avows that that consequently the U.S. District Court indicted the respondent for the offenses of narcotics, importation conspiracy. The second one is on possession of machine guns and destructive devices. And lastly, the third one, conspiracy to possess machine guns and destructive devices, which forms the basis of the subject charges. And accordingly, warrants of arrest were issued against the respondent as per the warrants of arrest that has been annexed, also dated the 25th day of March 2025. He further contended that following the indictment, the DEA Special Agent sought for the endorsement of the warrants of arrest issued against the respondent, seeking for his return and surrender to the USA to face the charges. Consequently, Interpol, through the NCB Washington, USA, issued a red notice number 2025/28845, dated the 14th of April 2025, annexed also the application. He further deposed that the subsistence of the U.S. District warrants of arrest and the red notice, the respondent was arrested at the Safari Park Hotel, Nairobi. He further avows that following the arrest, the Central Authority of the USA, through the DEA Special Agent, has forwarded a diplomatic note to Kenya, which is also annexed to the application for the extradition and surrender to the USA of the respondent to face the subject charges. So corollary, the applicant issued the DPP issued an authority to proceed, seeking for the endorsement of the warrants and the extradition of the respondent to the USA. So that forms the issues here. So the application is strenuously contested in a replying affidavit sworn on the 30th of April 2025, wherein the pith and the substance of the respondent contestation is that the charges are politically instigated, deposing that the ruling government in Afghanistan wants to gag him or silence him, his words, using the Attorney General's office. He vivaciously denied the subject charges. He explicated that he is a law-abiding citizen with no criminal history, and then currently he leads various civil, academic, and political organizations in Afghanistan, including Peace Cowan Group, the Coalition for Support of Rule of Law, and the Rana Institute of English Language and Computer Science. He avowed further that he is a law graduate from the University of Pakistan. He contextualized his political backcloth, deposing that his late father, Abdul QADEER, was a senior government official and was assassinated for political reasons. He asserted that he was a general in the Afghanistan Border Force and later elected to the National Assembly, rising to the position of being the first deputy speaker, where he was vociferous in opposing governmental misconduct and the United States interference in Afghanistan. So the respondent further, through his counsel, has filed a detailed and erudite written submission buttressing his respective arguments. So I applaud him for that. He paints the historical and geopolitical milieu between Afghanistan and the USA, which has precipitated, according to him, this application. He thus urged that the application is politically motivated in contravention to Section 16 of the extradition under the international human rights law, and also he has cited other international instruments, i.e. International Convent on Civil and Political Rights, ICCPR, and the United Nations Convention Against Torture, as well as Article 33 of the 1951 Refugee Convention, intertwined with our Constitution, Article 25. So I've consciously considered the same So I've analyzed, need not regurgitate, you'll have a look at it in the ruling. So there are broadly three issues for determination. One, offense, whether the offense is extraditable. Secondly, whether there is statutory grounds for refusal to extradite, and thirdly, whether there is an extradition treaty or agreement between Kenya and the requesting country. So in my perspective and my considered view, I find that the threshold has been met by the applicant. So I conclude, so I find that the application to be merited, so I'll endorse the warrants of arrest and subsequently direct that the accused person be surrendered and to be extradited back to the United States to face the subject charges.
For stay of execution. Your Honor, given the ruling that we've just delivered, much as we are guided by your wisdom, Your Honor, we are not satisfied and therefore will be preferring an appeal. And we believe we have sufficient grounds for that appeal. And therefore, Your Honor, based on Article 50 of the Constitution, which guarantees fair trial, Your Honor, we will be preferring an appeal, and therefore we pray that this court stays execution for at least 14 days, the period within which we are supposed to file an appeal. That will be our application, Your Honor. Therefore, our very kind prayer is that stay be granted, Your Honor. You are most obliged.
Before I respond to the application by counsel, I now want to make a comment on the affidavit. Section 8 of the relevant statute, that is the Extradition, Contiguous and Foreign Countries Act. Let me just get the correct one. That upon the order of extradition, the court shall commit the respondent to prison. So there does not arise an issue of transfer from one police station to the other. Therefore, the affidavit does not serve any purpose, and we pray that the court may ignore it. In response to the application for stay, first of all, the court, this court being a magistrate's court, a subordinate court, does not have inherent jurisdiction as proposed by counsel. And I would refer the court to the decision of Bononga J in Elijah Nyakebondo on Songo versus Republic. I didn't expect that issue to rise, so I didn't come with copies. But the decision is Elijah Nyakebondo on Songo versus Republic. But having said that, the fears of counsel are taken care of by the statute. That is again the Extradition, Contiguous and Foreign Countries Act under 9 subsection 2. Let's get it right. 9.1 and 9.2, Your Honor, sorry. So 9.1 says that whenever a magistrate commits a fugitive criminal to prison, which is what the court has just done, this part of this act, he shall inform the criminal that he will not be surrendered until after the expiration of 15 days. So the court does not, while the court does not have power, inherent powers proposed, even if the court had those powers, there's no need for the exercise of those powers because the respondent is entitled to 15 days before any surrender can happen. So we say that we are grateful. We are always privileged to appear before you, and we thank you.
No, thank you. So, Mr. Omega,
Yes, Your Honor.
fears have been allayed.
Yes, Your Honor. Given the nature of the proceedings, the DPP and the authorities involved will deport him immediately, thereby preempting the substance of the appeal. So that was our fear.
So I think to allay your fear, extraction contiguous cap 76, yeah? So we can have it, the order extracted that
Yes.
we invoke that.
Yes, exactly.
That's right, that's right.
Yes. So that in the 15 days you'll be able to
file an appeal.
file your.
Thank you.
You know, we're most obliged. I'd simply make an additional request that we be supplied with a copy of the ruling.
No, you get it in a minute.
Yes.
Yeah, once we're done,
Okay.
you'll get it. By noon today. Because I also want them to start the process of the appeal.
All right.
Yes.
Thank you very much.
Okay.
All right. I think my colleague has come in, so I can hand over.
Yeah, I think now, I saw him coming in.
Okay.
That's why I even concluded that. All right, thank you.
You're most obliged.
Criminal case 924/2019. Grace Ndanu Hassan, Charles Muiruri Muchai.
Mother.